Welcome to Newsmakers. I'm Tim White. Earlier this month, Target 12 took an in-depth look at how often law enforcement agencies in the state used force on a civilian and found the vast majority of the time that use of force was deemed justified after an internal review by the police department. You can catch that investigation under the Target 12 section of WPRI.com. For that report, we sat down with Attorney General Peter Neronha to discuss his role in use of force investigations and where he stands on police body cameras. Here now is our interview with Attorney General Peter Neronha. So I want to start with, and you and I have talked about it, but the protocol that you, I believe, launched in June, or you announced. You asked police chiefs to begin referring potential misdemeanor misconduct cases to the Attorney General's office rather than the traditional process of having town solicitors handle those. Why did you do that?
Well, I just thought it was important for two reasons. Number one, to bring consistency to those cases. We know that they're out there, but if you have different city or town solicitors who change over even within their cities and towns every so often, I don't think we're applying the same level of legal consistency to those cases, and I think that's what those cases deserve. I also think that my office, frankly, as the only office of professional full-time prosecutors, is best positioned to analyze those cases, bring the appropriate charges, and get hopefully the right results.
Are chiefs signing on?
Yes, every single chief signed on to that protocol, unanimously.
So we know about the Cranston police officer Andrew Leonard. We know about Providence Police Sergeant Joseph Hanley on those misdemeanor assault cases. Have you gotten any other cases referred since the guidance was issued?
You know, not in the sense that they have reached the point of an in-depth review. We have gotten lots of calls from departments. I think they're leaning over. They're leaning out farther to bring us things that may be on the margin. So things that don't necessarily involve the kind of things that you think of when you think of those two cases that you mentioned that are pending, and you know those defendants have the presumption of innocence, and those cases will play out in court. But so we're getting cases involving sort of things or calls about things that are more sort of internal disciplinary matters that, you know, we either will take a look at it or more likely just send it back to the department.
What do you mean? Police chiefs bringing you a circumstance and going, is this what you're talking about? Do you want to review this?
Yeah, exactly, because we're still getting a feel of what it is. So let me be very clear about what it is. You know, it's an instance where a police officer, in the context that we're really talking about, allegedly used excessive force. You know, that is, it's using force in such a way that may have gone beyond what the legal standard is, which is, were they being objectively reasonable when they use that force? Now, look, things come up all the time with police officers. There are complaints about police officers not being polite. Or there may be sort of theft-like offenses, which are also referred to us, and we sort of deal with sort of separately. We have a number of those that have come in over the years. But what we're really trying to get departments to do is to, you know, when in doubt, call us, and that's what they do. I will say, Tim, that as long as I've been Attorney General, and this was true to an extent with some departments when I was U.S. Attorney, police chiefs want to come to us, notwithstanding that they may have a city or town solicitor, in criminal matters to get our advice, because they know how often we do this. I mean, we're charging every year, on average, 5,000 felony cases. This is the office that is making charging decisions and applying the law, not only the statutory law, but Supreme Court precedent, really on a day-to-day basis. And so if you want the best look as to what a case is or isn't, this is the place to come.
What is it? What triggers them to bring it to your office?
Yeah, look, I think police officers, well, there are two ways they can come to us. One is from a citizen complaint, and we have a form on our website which sort of enables that to happen. It can be both civil rights, and it can also be excessive force. So there's a mechanism for complaints to come to us outside of police department. So at any time when you need to use force to bring a person into custody, and it involves more than simply putting, you know, pressure on the hand to put them in cuffs, they're going to do a use of force report. So you have to understand, I think, that many times police officers are going to use force to bring somebody who's not willing to go into custody. And so they still have to be written up as use of force reports, but they're not going to be necessarily the kind of things that warrant review by this office. At the same time, if someone is being struck, assaulted, beaten while in cuffs, that's something which needs to be brought to this office. If it's on the line, you know, are they compliant with the police officer's demands in terms of bringing them into custody, and conduct occurs or physical interaction occurs after that point? That's something that needs to be reviewed. You know, I don't have a sense with these chiefs that they're going to look at these cases and not be willing to bring them to us. I think that the real difficult issue, if we're being candid, is the cases that the chiefs don't know about. And the larger the department, the harder that is.
So that would mean a police officer is not filling out the use of force.
Sure. Look, I think this is why body cams are so important. And frankly, I think this is why civilian footage of these incidents is really helpful, because we may get, or the police department may get. We've had instances where cases have come to us because a police department got civilian footage, reviewed the civilian footage, and then went out and did further investigation and found, yeah, there's something we need to look at here. So I think when you take all these things together, civilian footage, media footage, body cam footage where it exists, and if we can expand body cams, I think that would be a huge step forward. All those things are going to put us in a position where we're going to catch the ones that step over the line. But we've got more work to do there for sure. And one of the things that I'm really working on, now is how do we make sure that we are getting those referrals? And what I'm likely to do, I'm still working out the mechanics of this, is ask police departments to certify at the end of every year that they have referred to us all matters that fall within the scope of the protocol. And the protocol now is very, very broad. And so I think that is going to really encourage police departments to send us matters that fall within that protocol. And I don't think.
And what if they don't, General?
Well, look, there's nothing about this protocol which under current state of law is mandatory. But I will say this, that I don't think you want to be a police chief. You don't want to be a police chief that's not willing to certify to the Attorney General that you have referred these matters to you as the protocol requires. A, you've signed on to it. Now I'm asking you to certify it. To refuse to certify it, I think would be a position that I don't think any police chief would want to defend. And knowing these chiefs, I don't think that's going to happen.
Before we get back to protocol, just briefly on body cams, and it sounds like the answer is yes, but do you think all police officers in Rhode Island should be equipped with body-worn cameras?
I do.
Okay.
I do.
And should that video be available to the public?
It should be available to the public, except where early disclosure would impact a criminal case.
So expand on that a little bit. A lot of people might hear that and go, well, body cam footage is no good if it's locked in a drawer.
Sure.
So what you're saying is after an investigation is complete, at that point, it's public.
Yeah, let me explain why that is. There are really two things that are going on there. Number one is pretrial publicity, right? I don't want a situation where witnesses are testifying for the defense or for the prosecution based on what they saw on Channel 10 or 12 or 6 or anywhere else, any other outlet, right? I want their testimony to be based on what they saw, not what they saw on TV. And we know that this happens, right? Or we know that even if it didn't happen that way, it's a great line of cross-examination, attacking the credibility of that witness. So it's very important that all the witnesses be identified and their accounts obtained before they have an opportunity to see it somewhere else. It's protecting the integrity of the investigation and ultimately the case. So if what the public wants in these cases is justice, however we define that, then protecting the integrity of that case is critically important, right? I don't want to lose a case because I didn't handle it the right way up front. So that's number one. Number two, there are rules of professional responsibility, specifically Rules 3.6 and Rule 3.8 that apply to prosecutors, where we cannot engage in pretrial publicity because it might damage the rights of the accused.
So many of those investigations can be held in, perpetual investigation, cold cases and perpetual investigation. Do you think the community plays a role in being able to police the police? Because, under Attorney General Peter Neronha, this might be effective. Under Attorney General Peter, Mary Smith, after you, this office has a very cozy relationship with law enforcement, and there might be some public distrust about whether or not this office, under maybe different leadership, is policing the police the way they should be under the protocols that you have written.
Yeah, look, I think, step back for a minute and let's talk about this. I think if you've got a case that isn't going anywhere, you're not going to bring charges, right? Well, at that point, there's no ongoing criminal investigation to be concerned about. But if I know I have a trial date in October, I don't think it makes a lot of sense to produce that video in August. So every case is going to stand on its own, and the policy as we've drafted it does not exclude the release, but it takes into account these two very important principles. One is protecting the case, and number two is making sure we comply with our ethical obligations. And so there's that. You say we have, and I understand why there's a perception of a cozy relationship with the police. We work with police officers every day as part of what we do. Obviously, there are principal witnesses in every case. Right. But I don't think and I'm confident that this office does not give a pass to police officers when they step over the line. I think our track record is clear in this administration, and it was clear when I was U.S. Attorney. We charged a Woonsocket police officer for assaulting a juvenile. He went to federal prison. There is no reluctance on the part of this office, and there was no reluctance on my part when I was U.S. Attorney to bring these cases when those cases are warranted. What's critically important here, and there's a lot of pressure from both sides. There's pressure from those who support the police not to go too far in terms of the prosecutorial discretion that we exercise, and there's lots of pressure from the other side where folks think that police are constantly stepping over the line. We've got to be immune to that pressure. We've got one job to do here, and that's to get it right and protect our case when we bring it. So we look at the facts, we look at the law. You know, I have the best people in this office analyzing these cases, including me. Not that I'm one of the best people, but I'm involved in it because I know how important it is. And we make those calls and we proceed. And look, we try not to, and I'm confident we don't overcharge, and I'm confident we don't undercharge. We try very hard to get it right.
The protocol is no small thing. It was announced at a very busy news cycle, but it's actually, in my beat, a pretty big deal. And you know, it's not lost on anyone that it came out after the killing of George Floyd. Was part of your thinking in doing the protocol to restore the public's trust?
Well, look, sure, but I'll point out that I was thinking this before George Floyd's death because there were two departments that brought us cases voluntarily.
Cranston and Providence.
Correct. And as we analyzed those cases, I thought to myself, look, why isn't every department doing this? And look, the use of force protocol that we hadn't been updated since at least 2007. And it was one of those projects we'd been working on for a while to try to bring it, to make the language, frankly, more relevant to today, to add in things like garrity, where a police officer doesn't have to give a statement, or if they're ordered to give a statement, we've got to do our investigation slightly differently. So we knew we needed to update this thing. And frankly, it wasn't even on department letterhead. We didn't know who authored it. We didn't know when it had last been updated, although we suspected 2007. So we knew it was one of the many things here that we needed to work on. But in the wake of those two misdemeanor cases, which were brought to us, I would say, in late April, I knew that we needed to expand this thing because, again, I felt like we were value added. Just from those conversations with the police departments. Look, they're not sure what this is. And so if they're coming to us and they need that kind of guidance, then we ought to be providing that guidance to every department in the state.
You mentioned that the two ways that it can come to this office, one through the police department, the other one is citizen complaints. Do you know if that phone has rang at all?
We have gotten complaints. Yeah, we have. And they're not always excessive force cases. It could be that somebody in a neighborhood is being harassed by somebody, allegedly because of their race, gender identity, whatever it is. And so we have gotten those. We have gotten those calls. There was a matter where somebody referred something to us which looked like there was an exchange among individuals in public service that might show a particular bias, and we followed up on that with the police department. So those things do come in. We have a very active civil rights unit here in our civil division, which works with the criminal division, because sometimes these cases can go either way. We have a strong footprint with the Rhode Island Commission on Prejudice and Bias. We do a lot of training through that group. We regularly attend their meetings. And so there are pipelines for us to get matters of concern. Again, Jim Vincent, when I was U.S. Attorney, brought several cases to us that I can recall. So there are lots of avenues. For us to get information through the door. People don't hesitate to call this office sometimes about things that aren't, frankly, are not in our purview. Take for example, we got a bunch of calls yesterday about the governor's new tip line about social distancing. That's not something which is within our purview. So people don't hesitate to call this office. I hope they'll do that. My goal here, you brought up community confidence. My goal here is to bring an independent set of eyes and to get this right. I recognize that that's a very difficult place, frankly, for us to be, because as I said earlier, no matter what decision we make, somebody's going to be unhappy with it. It's going to go too far or not far enough.
And let's talk about that. I mean, I wonder, are you worried about community trust? After the grand jury came back with nothing in Wyatt, because people see that video, and I don't want to relitigate that.
Sure.
We talked about that at length, but people see that video and go, man, how could that officer not have been charged? it's in the rearview mirror, but do you worry about the community trust after that decision?
I've always worried about community trust. I think if you're in law enforcement, I don't worry about it based on a decision that's made in a particular case. I think that's looking at something through too narrow a lens. You know, when I was running for office, when I was U.S. Attorney, and now that I've been here, being out in the community and getting to the community in a way that lets them see us is really important. It's why we did those expungement clinics and helped 454 people figure out whether they're eligible for an expungement or not. And we're doing that in part to help them, but also because I want them to see me in my office up close and understand who we are, because I think that's how you build trust. You don't build it with a case that can go either way. And we could have tried that case and the jury could have come out differently. The grand jury could have come out differently. I can't build trust based on the results of one case. All I can do is to try to get it right, put the evidence in front of a jury, trial jury or grand jury, and do the best job that we can. So, you know, I don't think you build trust based on one or two cases. You build trust by getting out in the community, letting them know what your priorities are, talking to them. I've got a community advisory board that I'm actually meeting with this afternoon. You know, I talk to them about the issues that we're facing here in the office. Some of them are law enforcement related. Many others are community type issues. But if you're the Attorney General, the U.S. Attorney, and you're not worried about community trust every day, then your thoughts are not in the right place.
When we come back, it took days to learn the results of this week's primary. What does that mean for the November election? Stay with us. You're watching Newsmakers. Welcome back to Newsmakers. I'm Tim White. When the polls closed on Tuesday's primary, only a handful of races could be called. That's because tens of thousands of mail ballots had to be counted, and we didn't know official results until much later in the week. For the second half, my colleague Ted Nesi talks to John Marion of Common Cause, Rhode Island, about what this could all mean for the November elections.
John Marion from Common Cause, it's good to see you. I want to ask you a little bit about the counting process happening with this primary, because it is different, and people want to understand what's going on with that, and we're getting a lot of questions looking ahead to the November election. So first of all, can you just tell people why the switch to mail ballots has caused it to take longer to count the votes in round? I should disclose we're taping this Wednesday evening, and people are watching it the following weekend, so we're in the midst of the count as we speak.
Yeah, so really there's two things. One's a function of the fact that we're using more mail ballots and voters are using more mail ballots, and the other is a policy choice. So mail ballots have to be qualified, meaning they have to take the envelope that the mail ballot is in and look at the signature on that envelope and compare it to the signature that they have on file for the voter, and that takes a little while. They have to process that paper, and that slows down the counting of mail ballots. The other is a policy decision, which is the Board of Elections has decided that they're not going to release partial mail ballot results. They're going to wait till essentially every mail ballot is counted before they release the mail ballot results. Now that made a lot of sense prior to 2020, when mail ballots were about 5% of the votes, because it didn't take long to count those. And they usually didn't tip the balance of an election. Now we're seeing about 50% of the votes by mail. And so not returning partial results means that there's just this big tranche of ballots that they're going to release at once that are about 50% of the votes.
So I was interested because I saw in Massachusetts last week, when they were having their count, they actually have each individual canvasser's office or elections office, whatever it's called, in the individual municipality, feed their ballots in, whereas Rhode Island, perhaps because it's smaller, brings the ballots to a central location at the Board of Election and counts them there. You know, do you think Rhode Island would be able to count faster if it was done locally, or do you think the centralization of that is helpful?
Like every decision, it has its pluses and minuses. It probably wouldn't count faster if we did it like Massachusetts, only because we would have to distribute those ballots to the 39 cities and towns. They'd have to do that qualifying. They'd have to feed it through the machine. That wouldn't necessarily speed it up, although if done properly, it could. It really, again, is just this policy choice about not releasing partial returns here, which is something that Massachusetts does too, right? They release what they've counted so far, and Rhode Island is choosing not to release what they've counted so far in terms of mail ballots.
One question I've been getting, as you can imagine, people are thinking, okay, this is 30,000+ mail ballots. Lord knows how many mail ballots there could be for the November election this fall, when you're going to have much, much higher turnout of every sort with the November presidential election. Is there a case for the board? Some people have asked, should they be, counting these ballots in advance as soon as they come in, kind of live as they arrive, not releasing the results early, but counting them, feeding the machines? What do you think of those ideas for other ways to structure this process that would be legal but might get to a count faster?
Yeah, so they actually are counting them in advance. They can count them up to 14 days in advance and under the law. And now with an executive order that Governor Raimondo issued last weekend, they can count them 20 days in advance. But they can't, like no state, they cannot release results until 8 p.m. on election night. What the board is planning to do, and hopefully they can execute, is to staff up so that as soon as those mail ballots are coming in, they're getting qualified right away and counted. And so as the late mail ballots come in late in the week before election day, over that weekend, they have the capacity to kind of process those quickly so that on election night, the vast majority of what's already come in is counted. And then they have to make a policy choice, right? Will they produce partial returns or release partial returns at 8 p.m. on election night? I think you're going to see a lot of demand for them to do it, and hopefully they decide to do it. Because if the Secretary of State sends every voter a mail ballot application for November, which is what I expect her to do, then we're going to see, maybe as many as 400,000 mail ballots. And that's going to put a strain on the system, but they are capable of making the necessary changes to handle that strain.
So, we've now done 2 of these elections under these pandemic conditions, much more mail ballots. We had the presidential primary that was delayed until June because of the initial pandemic, which was the first time the board realized, wow, what a change in their workflow is when they come in by mail. Now, of course, we're having this primary and finishing the count up as we tape this. I'm curious, John, what lessons you've taken away from these 2 experiences, how you think it's gone, especially the primary as their second round, and what you think should be top of mind for officials as they try to ensure, a smooth count for the November election, which has so much at stake.
Yeah, so considering that we've changed the primary mode of voting from, Rhode Island was 95% voting at polling places to, in June, 83% mail ballots, this time about 50% mail ballots. Things have gone fairly well. But as you said, there's still major adjustments that need to be made to the process. We still have on paper a process that is reflective of most voters going to a polling place. And we know they're not going to do that in November. So we still have to make these adjustments. Also, we need to just communicate better, right? So the Board of Elections did not, I think, communicate well in advance of this past Tuesday of how they were going to do this and when results were going to be released. They put out a press release about 9:30 on election night saying, hey, you're not going to get your results until Thursday, possibly. They need to prepare the press and the public for how they're planning to handle this. So I think there are both sort of policy adjustments and sort of adjusting people's expectations. But I do think, things went pretty well, right? We had over 3 dozen volunteers at polling places, and they didn't see significant problems. They saw sort of run-of-the-mill problems we normally see. The biggest one was probably that a lot of polling places changed because there are buildings that you can't use, like nursing homes, as polling places anymore because of the pandemic.
So one final question, John, I want to ask you, which is, you guys are the watchdog, the good government group. A lot of people look to you to feel confident about the system. About 30, 45 seconds left. Do you have confidence that mail ballots are as safe in Rhode Island and, will be counted as effectively and people will have their voices heard in the same way as they would if they walked into a polling place and voted?
No, we know that mail ballots across the United States in every jurisdiction, voters, have encountered problems with mail ballots because When you go into a polling place to vote, you put your ballot into a machine and you know that it got counted. A mail ballot, you put it into a drop box or the mail and you don't know it got counted. And if you filled out the instructions wrong or didn't follow the instructions, it might not get counted. So a lot of this is about educating voters to fill out their mail ballot correctly. That qualifying that I described discovers a lot of problems. And there are hundreds, if not thousands, of mail ballots that will be rejected, and those are potential voters who are disenfranchised. So it's important for voters, if you're gonna vote by mail and you wanna have confidence in it, track your mail ballot. The Secretary of State's website has a tool, you can follow it along the way. If a problem happens, you can solve it. Rhode Island allows people to what's called cure their mail ballot. If there's a problem, they made a mistake, not following the instructions, they can make sure it gets counted. So pay attention to the process. If all the voters do that, then yeah, voters should have all the confidence in the world.
John Marion, thanks for taking the time to talk with me.
Absolutely. Thanks, Ted. Nice to see you.
Thank you for watching. If you missed any of it, you can catch it on WPRI.com. I'm Tim White, and we'll see you next week on Newsmakers.